Weil Gottschall, and a member of our litigation practice group. And I have the privilege this afternoon of introducing the moderator of our panel, and that is Judge Michael Mukasey. Usually these introductions tend to recite the entire resume of our moderator, but in this particular case, we'd be here well into the evening. So I will touch on a few of the many contributions that Judge Mukasey has made to the law. Judge Mukasey first served as an assistant United States attorney for the Southern District of New York. He was then appointed to the federal bench in that same district by President Reagan, where he served for 18 years, with 6 of those years as the chief judge. After that, Judge Mukasey served as the 81st Attorney General of the United States under President Bush, and now Judge Mukasey is in private practice in New York at Du Bois and Plimpton. There are few among us, although certainly more in this room than usual, who have seen the development of the law from so many vantage points and have made such pivotal contributions to our justice system in the process. So with that, please welcome longtime friend of the Federalist Society, Judge Michael Mukasey.
Thanks. There we go. I want to thank Joe for that kind introduction. This topic here, as you know, is the role of the modern state attorney general, and the reason for that modifier, I think, becomes apparent when you consider that back in the 1930s, Justice Brandeis, in an opinion in a case called New State Ice Company versus Liebman, described the role of the states as, among other things, as laboratories of federalism. And the idea was that states would pass laws, in that case, wage and hour laws. Courts would consider them. They would either have effect or they would either succeed or fail. And other states would learn, and the system would chug along with states as serving as examples for one another. The role of states, and of course of state attorneys general, has evolved mightily since then. And you're going to hear from this panel how it has evolved and the powers and responsibilities that they exercise. You'll hear that states have come a long way since then, not only through using consumer protection laws, but also issues relating to relations with foreign countries, environmental issues, the relationship between state attorneys general and the Department of Justice, and their relationships with one another. We have 3 current attorneys general and 1 former attorney general. Sitting to my immediate left is Brenna Bird, Attorney General of the state of Iowa, who took office in January 2023 and has been fighting the good fight since. Moving to the left is Mark Herring. This is the order, by the way, in which they will speak. He's a former Attorney General of Virginia, now a partner at Aiken Gump, and he served for 8 years as AG of Virginia, and he's also, to me at least, notable for having been elected to that office without sending any threatening communications to his opponent. So perhaps he can explain how he managed that. Next is Derek Brown, the Attorney General of Utah, who has also been fighting the good fight in his office and cutting out some of the dead wood. And finally, Attorney General Steve Cox of Alaska, who I think has probably the widest array of powers and responsibilities of anybody who has served in any of the offices of state AG, and who has been at it since September? August 29th, okay. As I said, September. And has been cutting a bloody swath ever since. So we'll start off with Attorney General Bird.
Well, thank you, Judge. I appreciate that. And I, along with all of us, I think I could say, sure, appreciate the chance to serve as Attorney General. It's a wonderful thing to get to serve your state and uphold the Constitution, defend our laws, keep people safe. It's got to be one of the best jobs ever in elective politics. But one of the things that I did when I was elected, I was just elected in 2022. I think you could probably say I modernized the office, because My predecessor, who I ran against, he was elected in 1978 when I was 2, so he had been there for a while. We made some major changes in the office going forward, and I think some of those reflect some of the changes that you see in AG's offices. But we instituted a statewide cold case unit to look and investigate the over 400 unsolved homicides that we have in our state, to make sure that families and surviving communities know that someone always cares, will always take those leads, and we are always looking out for those types of cases for justice. And then also have a Solicitor General division. Our Solicitor General is here, Eric Weston, somewhere. There he is, right there. And a great division there, fighting for what is right, for the Constitution, upholding our laws. And as part of that, we also have what we call a Farm and Freedom division, defending agriculture, our laws, and our freedoms. That's also what some states might call special litigation, but I certainly think Farm and Freedom does a better job of explaining what it does in a state like Iowa. So, Iowa hadn't had that kind of arrangement in the past, and it certainly made a big difference going forward. We have, I'm glad to say, people from all over the country who move to Iowa to work in our office, and Iowans work there too. It's a great opportunity and great environment, a wonderful chance to get to serve and do some very challenging legal work. So our Solicitor General division, of course, does the more specialized appellate work, but the special litigation unit has been very, very busy. And just to hit a few of the types of things that we get to work on, we had Iowa versus SEC, the SEC greenhouse gas disclosure rule, which we're very glad to have great success there. Iowa versus EPA, which was the challenge to President Biden's waiver to the California Air Resource Board, also known as CARB, which is a pretty terrible name, but that's what it's called, that let California ban traditional liquid fueled powered trucks and instead favoring electric trucking. And then others that were very important, including Iowa versus the CEQ, the challenge to NEPA, the National Environmental Policy Act, and great success there as well. So, there are a number of different things that we've been able to work on, make a big impact for our state and for our country. A lot of those we work together as AGs, and our staffs particularly do, on amicus briefs and comment letters and other letters, investigations, all of those things, cooperating together. And as I was reflecting on that, I was noticing how many people, and I think this is a bipartisan development as well, who work in an AG's office go on to other things as well, sometimes on the bench as U.S. attorney, as my recently former chief deputy now is U.S. attorney. And it's a wonderful thing for our state for them to have that type of experience and be able to go on and hold those types of roles. And the way that they work together across states, forming those bonds of friendship and professionalism, I think is a credit to our country and to our profession as we work together on things. I think not unlike maybe, although it was a different time, what the founding fathers may have done, building those friendships that stand the test of time. And it's especially meaningful for me as I'm walking through the lobby to see people who haven't seen each other in a while and that sort of thing. That is what it is all about, because we are about ideas, but we're also about people and those relationships and working together for the things that are so important that we care so much about. I thought too, I'd just briefly touch on another area that you will see our offices working on. I would call it issues within big tech. So, for example, our office is suing CoinFlip and Bitcoin Depot, the crypto ATMs that have been involved in facilitating people being ripped off and conned out of significant money by con artists, as well as a lawsuit against TikTok. That's still going on in our office, that lawsuit. It basically is about the fact that they represent that TikTok is safe and appropriate for kids 12 and up, which it obviously isn't. We did an investigation and found sexual content, drug content, very troubling content that would certainly not be appropriate for anyone other than an adult, and quite frankly, some of it's probably not appropriate for an adult either. But there are some great opportunities that we have as attorneys general when we have our consumer protection responsibilities. And what we can do there is, although many people wouldn't be able to get the changes that are needed. When AGs, when we work together, we can get some results, and we can help people and end some of those bad practices so that we can have the benefits of technology without some of the heavy costs. And certainly nothing should come at the cost of our children's safety and their mental and social well-being. So, with that, I'm really interested to hear what everyone else has to say as well. But I must say, an AG's office is a great place to work as a lawyer.
Thank you. We'll next hear from former AG Herring, who can talk about his 8 years in Virginia.
Well, thank you, and good afternoon, everyone. I'm really glad to be a part of the panel and to talk about one of my favorite subjects, which is what it's like to be Attorney General and the work that AGs do across the country. General Byrd started off her remarks about what a great job it is, and I couldn't agree more. When I was AG, I used to tell people it was the best job I've ever had or ever will have, because I love practicing law, I love public policy, and most of all, I love helping people. And when you're the Attorney General, you get to do all three of those things every minute you're awake. Now that I'm a partner at Aiken Gump, I tell people that being an ex-Attorney General is the best job ever. AGs and their offices continue to emerge as a more important institution of American government with each passing decade, and it is continuing to evolve. I think a recognition of the growing importance of state AGs is reflected in the number of long-serving members of Congress who leave that institution of government to try to become attorneys general of their state. Examples include Javier Becerra, Keith Ellison in Minnesota, former Attorney General, now Governor Jeff Landry in Louisiana, Todd Rokita in Indiana, Anthony Brown in Maryland, Royal Labrador in Idaho, and there are probably others that I haven't mentioned. And I think one of the reasons is because the office allows them to do so much more. The decision to litigate or prosecute does not require consultation with 534 other individuals. If you think it's the right thing to do, you do it. You have full authority of your office from the moment you're sworn in. And the tools that attorneys general have give them an ability to be nimble and accomplish things that maybe other institutions of government can't. Most AGs are elected on a partisan basis, 44. Right now, the split is 28-23 if you include district, and that will change next January with the Virginia elections behind us to 27-24. And I think the institution has changed in a number of ways. I'll just touch on one right now, and maybe we can touch on a couple more later. But one way is that over the last couple of decades, it has evolved so that the attorneys general of the party out of power in Washington is now seen as an additional check and balance on executive power. And that's especially true when there's a perception among them that the other co-equal branches might not be exercising all of those checks and balances in a way that checks the executive authority. I think one of the reasons is because AGs of both parties are always relevant. And that may be stating the obvious, but the minority party in a legislature like Congress can oftentimes be sidelined, including their agendas. But all AGs have complete authority over all of their offices and powers. And so it has evolved over the last couple of decades that the party out of power, those attorneys general tend to challenge administrative actions more often. In preparation for today, one of the things I did was pull out some notes from a talk I gave a year ago, immediately after the 2024 elections. And that was the first bullet point of my notes, was that regardless of party affiliation, all state attorneys general are in full control of their offices. And I looked and saw that the predictions that we made are exactly what we saw. So the only difference is the pace and the speed and the quantity of those cases has continued to increase. And so the challenges to executive authority started off at a frenetic pace with TROs and motions quickly out of the box. And then over time, as those cases start working their way through the court system and kind of slow down a little bit, we anticipated then, a year ago, that with different enforcement priorities at the federal level, that the Democratic state AGs would perceive a void in regulatory enforcement that they would want to fill. And so we've started to see that happen as well. So that is a trend that really only started probably with the Obama administration. There were a couple of cases maybe under the Bush administration. There was even a sort of a honeymoon period under the beginning of the Obama administration, but it was really the Affordable Care Act litigation where the Republican AGs were like ready to file as soon as the bill passed. And from there, that trend has continued to grow. All of that aside, I did want to mention also, the impact of the Supreme Court cutting back on nationwide injunctions. I think initially Democrats thought, well, this is not going to be good for us or good for Americans. But I kind of wonder if it puts more focus and attention on decisions that state AGs make, whether or not to join these cases. I think maybe in the past, whether it's a Democratic state AG or a Republican, if they're the ones who are challenging executive authority, if they don't join, they might have to explain why they didn't. But if an injunction was granted, their constituents, their state, would get the benefit of that injunction. If nationwide injunctions are cut back, it puts a lot more of a spotlight on the decision to join or not join, because it may mean that even if you are of the same party as maybe 18 other AGs who are challenging something, if your state is not a part of that litigation, your constituents might not get the benefits of it. So I think over time, it's going to put a lot more emphasis on state AGs' decision whether to join those or not, and can also have important funding decisions. So I think those are a couple of developments. All that aside, while there is a lot of focus and attention on those partisan divisions, the big cases, I think as state attorneys general do more work across the aisles, working together on a bipartisan basis than any other office. Despite the partisan differences, there's a lot of that work that continues. Big tech was one, social media litigation, antitrust, consumer protection, public safety, opioid epidemic, human trafficking. All of these areas, there's a lot of cooperation. And despite the focus on major cases, a lot of the work that AGs and their offices do is outside of spotlights.
Thanks very much. I hope that eventually everybody will address the degree to which attorneys general consult with one another and with the DOJ on issues of policy and how it develops your strategy in litigation, because it must be a pretty complicated machine. We'll now hear from Derek Brown, the AG of Utah.
Great. Thank you, Judge. And the reality is, just at a 30 or 40,000 foot level, we do consult with each other. We know each other behind, in terms of what's going on with the offices. I have a Solicitor General for my state, Stan Purser, where's Stan? There's Stan. So Stan's the Solicitor General for Utah, and he works with and knows the other Solicitor Generals from the other states. Eric, who is General Byrd's Solicitor General. You've got Alan Hurst, who's the Solicitor General for Idaho. I mean, they know each other. We do work together on a regular basis on so many of these issues. And as Mark mentioned, it's funny. I have most of the questions I get from people tend to involve legal issues. But when my friends approach me and ask questions about this job, they'll ask, ironically, the very thing you asked me is, are you enjoying it? As a lawyer, I literally cannot fathom a more interesting legal job on the planet, because the breadth of issues that we're dealing with is just mind-numbing and interesting, and there are no 2 days that are ever alike. I mean, I'll lay down in bed at night and think through the different issues that I dealt with during the day and just think, what an amazing opportunity. It's like we're juggling 17 balls. The only worst job, honestly, is to juggle 23, which is my chief deputy, Dan, who's right there in the bow tie, who has to juggle even more than I do. But one of the things that I find interesting is, and I've been a member of FedSoc for many years, and in fact, I started, if it's okay if I just talk a little more globally in terms of my philosophy, I I practiced at Sidley Austin here in D.C., just around the corner a number of years ago, in the appellate and litigation section. Ironically, one of my, right next door to me, funny enough, some of you will appreciate this, was Ryan Nelson, who's now on the Ninth Circuit. I don't know if I know he's here at the conference. And then a few doors down the hall was Mike Lee, who now is Senator Mike Lee. Then he was just plain old Mike. And it was funny because he would always geek out about the Constitution. And I mean, most people, if someone starts talking about Article 1, Section 8, the Enclave Clause, or letters of marques and reprisal, you fall asleep. He just comes wide awake, like he just loved it. But ironically, I practiced with him. I moved back to Utah, and I had the most frustrating experience you could imagine. I was in the Utah House of Representatives, which meant that we meet for 45 days a year, starting the day after MLK Day, and then 45 days later at midnight, the clock strikes midnight, everything ends, every bill that hasn't passed dies, and then we don't come back until the following year. We solved problems. We moved fast. We were nimble. From a legislative standpoint, we could actually do stuff. 4 years after doing that, then Senator Mike Lee then called me up and said, will you come and work with me, help me run my office? And I agreed to do that. And then I went from there to seeing what they do at the federal level. And talk about molasses. I mean, they just talked about a lot of stuff and basically did nothing. And it was the most intensely frustrating experience of my life, because all of a sudden I went from a body that was actually doing stuff to a body that was mostly just talking about what they would do if they could do stuff or had the votes to do stuff. And so that whole process for me showcased the importance, ironically, of what attorneys general do in this country, because what that inaction at the congressional level has done. And we've brought that to sort of new heights right now. But in the last 5, 10, 15 years, the level of inaction at the congressional level has opened up a vacuum. And that vacuum needs to be filled by someone or some group. And generally speaking, if nothing was done, then agencies tended to have all the power, and then they would then have new bureaucratic rulemaking. In fact, when I worked for Senator Lee, at the time, he had a cabinet when you walked in his door in the Hart Building. And the cabinet had on the top of it, this was the year 2016. The year prior, it had all the laws passed by Congress. And there were 700 or 800 pages. So it was like a ream and a half of paper sitting on the top of this cabinet. Inside the cabinet was effectively the Federal Register from the same year. And it was roughly 70,000 pages. So when you stand it end on end, it was 3 different stacks, but it was about 11 feet high. And we did stack it once just for fun and to take pictures. But it was a real visceral example of the type of overreach that we tend to see. And I just ran a statewide campaign for a full year, and we felt this in Utah. I don't know if you know this, but in my state, 2/3 of the entire state, so 2 out of every 3 acres in the state of Utah, is owned and controlled by the federal government. So, and in fact, ironically, the county my father-in-law lives in, it's 93% owned and controlled by the federal government. So literally, you'll have families that have a bureaucrat that comes in, chains off a road that they've used for generations and says, okay, it's now shut, nothing you can do. And the family will be like, we've used this for 5 generations. What do you mean? Well, it's closed now. You better not use it or else you'll get arrested. Can we talk to someone? Is there some process? No. Call your congressman. That's about what they would hear. So anyway, my point is that opened up this vacuum, and I think the pulling back of the Chevron doctrine has created an opening for attorneys general as a group to step into that vacuum and fill that vacuum. And so we do 2 things. One is we work together to police that 10th Amendment Federalist structure where the federal government overreaches. And then another thing that we can touch on and maybe have some fun with is where, as states, my job is to protect the sovereignty of states like my own, not just from the federal government, but from overreach by other states as well. And we're seeing a lot of that as well. I was hoping the Supreme Court in the pork producers case would give us some sort of per se test on extraterritorial effects. They didn't do that, so we're still kind of, as General Byrd knows, we're still struggling with what does that look like when you have, an economy that's the 6th largest in the world, otherwise known as California, who has lots of, they are famous for taking bad ideas, I think, and making them worse. And they have an impact on my state. So what do you do when they do that? So that is where AGs, as Mark mentioned, they're nimble. They can step in, they can represent the state. I mean, we literally, through the parens patriae doctrine, we can assert what's effectively third-party standing on behalf of the citizens of our state, and do it in a nimble way that's much quicker and more effective than, say, jumping through all the hoops of Rule 23, numerosity, commonality, all that sort of thing. So those are the kinds of powers that AGs now have. And as Mark mentioned, you're seeing a lot of members of Congress step away from Congress and into the role of AG because they have those kinds of powers. We can be nimble. We can identify problems in the morning when we read an article about something, and by 4 p.m., we've actually taken some action to do something about it. And so we can talk about some specifics, but that's what makes this role such a fascinating and interesting role. So on that note.
Okay. Attorney General Cox, I think, is newest at this. He said he's been serving since August 29th. But has, I think, the broadest range of authority of anybody on this stage. So it'd be good to hear from him to sum up.
Well, first of all, thank you for having me. Thanks to the Federalist Society for having me. I think my first Federalist Society convention was 2005. So this is 20 years, and this is the first time I've been invited to be on a panel. I think I'm the person on the panel, why they call it a modern attorney general, because I'm the newest. I'm like 2 months modern. But I'll tell you a little bit about why I love this job better than any other job I had. And I worked at the Justice Department. That was the best job I ever had during the first Trump administration. And I do think it'll probably be the best job I will ever have. But the Alaska AG's office is unique. Everything about Alaska is really unique. But the AG's office is no exception. The AG, like other state AGs, we're the chief prosecutor, we're the state's litigator, but we also wear a lot of other hats. So, for example, the governor doesn't have his own general counsel, so I'm the governor's general counsel. The executive branch agencies don't have their own lawyers. Their lawyers actually work for me. The district attorneys in the state are not elected, they're appointed by me, and so they work for me. And so in that respect, you do wear a lot of very different hats. The question of who is the Attorney General's client is always a fascinating question. It's especially fascinating in Alaska. We were unique in that we didn't have a state solicitor general up until 2 weeks ago. And we have a state solicitor general, Jenna Lawrence, and she comes from a couple of other states where she worked in the SG's offices, so she's already worked with a lot of the other states in the multi-state, amicus brief writing, the letter writing, all of that happens, all of the stuff that happens between the states, she's been a part of, and she'll be a huge asset to us. I also have Connor Campbell in the in the room. He's a former assistant district attorney. We have 150 of DAs or assistant district attorneys in the state. And then we have about 150 civil lawyers as well. So I have about 300 lawyers scattered throughout the state. And I thought I knew what the unitary executive branch was, but until I got to Alaska, which is, the unitary executive, like for real, because the governor appoints everybody. So everybody in the executive branch, all the commissioners, all the state boards and agencies and state corporations, all the leadership is appointed by the governor. So the governor really does direct the entire executive branch, no question. And that makes it a very fun and interesting place to be an AG. We also have to sometimes advise the legislature. The legislature will sometimes ask me questions, and sometimes I'm required to give them an opinion. If the courts or parts of the judiciary branch are sued, I sometimes have to represent them in litigation. We also have something that I don't think I've ever seen in any other state AG's office. So in the federal world, you have the Office of Information and Regulatory Affairs, OIRA, within the Office of Management and Budget. They're basically the regulatory czar for the federal executive branch. So they set the regulatory agenda, they do the regulatory budgeting. It's a bunch of green eye shades folks. They're doing kind of form and substance along with OLC at DOJ to make sure that, you know, all regulations are approved. That office is in the law department in Alaska. So every regulation that comes out of every executive branch is signed off by the law department. And then the regulatory reform, you know, we just had an executive order. It's called an administrative order that was put out maybe 2 or 3 weeks before I started the job to cut back on regulations and the cost of regulations and to make permitting more transparent, really to sort of spur economic development and attract investment into the state. We have aggressive goals of, you know, trying to reduce costs by 25%. All of that is run out of my department, and of course we work directly with the governor's office on that. And so that's another reason why the Alaska AG office, it's unlike any other AG's office, and it's a total intellectual smorgasbord of issues that you get to deal with. I think I used to say about every other job that, you know, no day was ever the same. I think that's sometimes, you know, a cliche, but I think it's absolutely true in this job. And I've loved every minute of it, even though it's just been a little over 2 months. So,
I wonder whether any of the AGs on the stage can speak to the question of whether you've ever find yourself in an adversarial relationship with other AGs on matters of either policy or litigation, how you hash that out. Anybody?
you do.
Well, no, we do, and what we try to do. I mean, well, let me go back to the what I had mentioned earlier, because one of the a lot of it is, for me, I mean, I go back to the ACA decision and Robert's opinion, the Chief Justice opinion, which I didn't like at all, but he did use the phrase, states are separate and independent sovereigns. Sometimes they need to act like it. That was his quote. So I believe in doing that on behalf of my state. And so we have examples where other states will have extraterritorial effects. And so we do have to, I think, police. In fact, perfect example, can I bring up the one we just talked about? General Byrd's team does a great job, and Eric just wrote an amicus brief dealing with an issue involving the SEC, where remember how they were requiring climate disclosures by companies, and there was a lawsuit brought by AGs. I believe that's on stay now in the 8th Circuit? Okay, well, California, of course, taking bad ideas and making them worse, as I mentioned earlier, they basically did the same thing, passed the same bill that would cause, they said it just applies to California or any company wanting to do business in the 6th largest economy in the world. Well, on that note, so that is now being challenged, and Eric's written a brief within the General's office on that very thing, which we are joining today. And those are the kinds of things, by the way, take note of that, Stan, we need to join that. And for the other SGs out there, remember that, I see 2 of them right there as well. But that is when that's one where we're gonna be in an adversarial role with California. And it is what it is. There are cases where we're not, where we do work in tandem though. We have lawsuits against social media companies. Meta is one example where we work in tandem. Sometimes we not only work in tandem, sometimes one of us will do something and then another state will follow suit. I mean, recently we filed suit after a long drawn out negotiation period. We filed suit against ALO, which is I believe the largest owner of pornographic websites on the planet. And there was a little bit of trickiness there because they're also based in the island of Cyprus. So from a jurisdictional standpoint, you can understand some of the difficulty, but we filed suit in federal court in Utah, filed a consent decree, and they agreed that any video on any of their platforms, if someone was over 18, they'd have consent, And if they're under 18, it would be taken off. Okay, so we're the first state in the country to do that. As soon as we announced that, and we did it in tandem with the FTC, I had other state AGs calling me going, hey, what did you just do? Like, that's a great idea. And then my answer is, it's a great idea, and then I put their folks in touch with my folks. And so the reality is there is a lot of coordination, and not just on partisan issues, but I mean, like that issue with ALO, I've had Democrat AGs reach out and say, what are you doing? So there's, like, you may read more about the more sort of highly charged partisan issues, but there's a lot that are not necessarily partisan as well that we work with on a regular basis.
I think Justice Brandeis would be proud. You're a laboratory of federalism.
We are a laboratory, absolutely.
Example. A.G. Byrd?
Yeah, well, I mean, obviously the California situation is one where there's a lot of conflict between states in California. I think, too, there can be conflict between people that you might think might normally be aligned. So there can be Republicans that see things differently. And one of the things about being Attorney General is it's not a political office in that way. Instead, it's our job to look at the law and the Constitution and do that. And sometimes two good people can come to very different conclusions, and that happens sometimes. And I think that it illustrates what kinds of colleagues we have, because, you know, and I mentioned this earlier, and I think it's something that I've noticed very, very important. Culture matters, and how people relate to each other matter, and that kind of courtesy and long-term relationship are very important, both working across the aisle, but also within people who are usually aligned. And so even when there are conflicts that are very important to various states, and they don't come up with frequency, but they do sometimes, the way that they are handled and the way that staff and AGs treat each other, I think is a good model for how people can work together. And certainly, you know, we've seen within different political spaces, maybe the big white dome building in this town, that it doesn't always work that way. And it's not something that I take for granted. Culture is something that everybody has to invest in and be part of and be committed to. But there are times that even Republicans will disagree with one another. I know Democrats too. And then there are times that people can work together across the aisle. But I think very important that we continue to work together in those ways. And there are many times there are conflicts between states too. There are many times, you know, California, I think, is the most public example, but there are many other times where issues come up where states will be on completely opposite sides of an issue.
But I do think that the state AGs recognize that different states have different concerns or different interests at stake, and work hard to try to make sure that those differences don't spill over into areas where there is common interest and common ground. And I think AGs, more than any other office holders, have been able to try to make sure that those differences, when they come up, don't interfere with the ability to work together on other issues where there are commonalities.
One issue that I think many states have in common, although they approach it in different ways, has to do with ownership of land by foreign persons and entities, specifically China buying up lots of land around the country. And I think states have dealt with this in different ways. I was wondering the degree to which you think that and issues that are similar ought to be left to there's a Committee on Foreign Investment in the United States called CFIUS within the federal government that is supposed to handle those issues on a multi-agency basis. I'm wondering the degree to which that issue is left to the federal government and the degree to which the states handle it themselves.
I might take that one. So as somebody who was born and raised on a farm in Iowa, and as you can imagine, farm ground and ground is very important to our identity as a state. We've had long-standing laws in place to prohibit foreign ownership of farm ground, and it's worked really well. I do think, though, I think that states should be able to regulate there, and it's certainly a very important issue, but probably some additional oversight is needed. And I'm not sure that the federal government is doing everything they should be doing in this regard, because many times, as you know, different entities can be created, and it can be a little bit hard to know who exactly is behind the various entities. Our farm ground statute, it's probably been around for over 20 years, something like that. So it's been a long-standing law in our state. Many other states have also adopted that. I think it certainly makes sense for states to have an important role there. There should also be additional federal involvement so that we can protect our national security interests and make sure that we're not allowing, for example, the Chinese government or an affiliated company to own land in a strategic location that could jeopardize the safety of our citizens of our country.
Judge, can I add on to that? I mean, we have a bill that was just passed in this last year specifically dealing with Chinese ownership of land, because there's a lot of Chinese companies or companies associated with PRC that are buying land. And for some very odd reason, they really like land that is strategically close to military bases and our national base. I know, I'm sure it's purely coincidental. But so we've passed a law specifically dealing with that, enforcing divestiture, and the Attorney General has given a role in that divestiture process as well. But that being said, I mean, because property law tends to be so highly rooted in state law, I think that's where, that's why it makes sense to have the states get involved in the process itself and divestiture and that sort of thing.
But do you consult with the federal government, the Defense Department, and other people on issues like that?
We don't. I mean, our legislature may have, but any idea? I doubt they really did. I think they, a lot of it is again, it's being nimble and being responsive to what was a perceived and immediate threat in my state, and they could consult with the federal government, and they could talk to their members of Congress, which they did, and their members of Congress could talk about what they could do if they could do things. But by and large, they're not going to. So that's why the laboratory concept, I think, still works. They step in, and in the matter of a couple of weeks, they passed a bill, and it was done. So,
they call it national security for a reason. I just wonder how it is that there's no consultation with the federal government. That just seems odd. A.G. Cox, when we were having, go ahead.
Yeah, I'll just add. So I'm 2 months in, so I haven't picked a fight with China quite yet.
And there's always next week.
I don't think I've seen the news about the Chinese buying up land in Alaska so much as I've seen it in other states. It's been a while since I've actually looked at the CFIUS laws, but I guess on the land side of things, the question I would have is whether that really counts as critical infrastructure, where CFIUS really has a really good, strong jurisdictional hook, or whether the states do, because property really is kind of a state concern. The states do have a role to play. I also think China is a real blind spot at the federal, state, and local level, and in the private sector and the consumer level. And so I do think the states have a big role to play. I look at the state as being, along with other consumers, families, businesses, other governments, as we're all consumers, and we're at the front lines of this geopolitical fight that we're having with China. And China does have a law in its books dating back. They have several laws in the books: national security, intelligence, and law enforcement laws that have been passed in the last 10 years in China, including the National Security Act in 2017 that requires explicitly companies and individuals over there to cooperate with the intelligence community in China. And so that's a real risk, and I do think the states have a role to play in that front.
During our conversations when we were getting ready for this panel, you talked about the commerce that flows through Alaska and the issues and problems that raises for you with regard to the security of the country. You could discuss that a little bit with us and enlighten us. I think it'd be helpful.
I mean, Alaska, not only can I see Russia from my backyard, I can see China from my backyard. But we're actually, I think in Alaska, we might actually be closer to Asia than to Washington, D.C. And so it is a real a concern for us. And, you know, if you ever thought about, you know, things going really badly with respect to like the issue of Taiwan and whether there was an international conflict over that, Alaska would be, you know, an area for deployment. And so we would absolutely have a huge heightened risk from an infrastructure perspective, because if our infrastructure, you know, whether it's utilities or whether it's telecom, contains equipment that's manufactured over there, and those manufacturers have a responsibility to under their Chinese laws to activate those back doors and kill switches. Like, that's a real problem for Alaska, but it's a real problem for the country, and so we are going to be looking at that. We also see it from the perspective of energy development. You know, Alaska has some of the most diverse and vast energy resources, and a lot of them are oil and gas related, right? And over the last 5-10 years, we've seen this push, not just from the federal government and the Biden administration and the Obama administration, but also in the financial institutions, the insurance industry, and all of these industries that were going hard into the ESG movement and really pushing back on Arctic energy projects. Well, a lot of that money, they didn't just stay on the sidelines. It went into these renewable projects, these clean energy projects, the equipment for which, the resources for which were all coming from China. And so we care about this stuff a lot.
We've been talking about the enforcement of laws, and there's a subject that lurks over the law generally, and that has to do with non-enforcement of laws. And I'm wondering if I could get your feeling about two phenomena in that area. One having to do with marijuana laws, which as far as I know are still on the books, but there's a pattern of non-enforcement by both the federal government and various states. And then, of course, the immigration laws. And the degree to which you interact with other AGs, with the Department of Justice on those subjects, I think would be of interest to, certainly to me, and I think to the rest of the people here.
I can
Nobody wants to volunteer.
Do you want to start?
Yeah, sure. Yeah. So I think every state is different when it comes to the marijuana issue. Recreational marijuana is not legalized in our state, and so we enforce the laws that are on the books. It's certainly an area where there's been a lot of change. I think one thing that is very important to think about, big picture when it comes to non-enforcement of laws, something like prosecutorial discretion is very important and valuable, and as a prosecutor, I understand the importance of that. But when it becomes a blanket type of non-enforcement, I think people have to engage in a very thoughtful process and really carefully consider, because it's important to the constitutional separation of powers that we respect that the legislature makes the laws. Of course, the governor would have a role in signing those laws. You have the judicial branch. But I think we have to be very faithful to our constitutional oath when we're thinking about whether to enforce a law or not to enforce a law in a blanket type situation. So that's a part of the discussion that I think we could use more thoughtfulness and working through some of those problems, because it will come up in more than one area. You know, we've certainly had great, on the immigration issue, just great cooperation with the federal government. And I can say that Iowa has 99 sheriffs that are elected, and I think each and every one of them has my cell phone number. If there was a problem with ICE not picking up detainees or not being in touch with our sheriffs who run our jails, I would be the absolute first person to know about it. And at this point, things are going very well that way. Of course, it's not an easy thing to try to enforce immigration law after years and years where those laws were ignored. But as far as the progress that's been made, I think it's nothing short of very impressive what the federal government has done with the 287G agreements that allow law enforcement to be able to work with immigration and to help in those ways. And the level of cooperation that I've seen is very important to me. And I contrast that with, it was about 8 years ago or 7, I had a sex offender who was not legally present in our country and was very, very concerned. And it took hours and hours of trying to call the right person to see if during the time that he was in my county's jail, they could put a detainer on him and come by and pick him up and deport him so that we would know that people would be safe. And I contrast that to what's happening now, where it's working really well. So those laws are enforced in Iowa.
Well, in our state, we've also had a number of sheriffs, and we've worked with them, sign the 287G agreements, because one of the things that, we don't obviously enforce immigration law at the state level, but, if we catch someone who is, say convicted of or accused of a felony and they are here illegally, then there's a process by which we do work with the feds. Now, the problem has been in the past that the feds have made it brutally difficult to actually work with them. That has changed in the last year, as many of you know. The number of requirements that they had for facilities to be ICE facilities were so, and you probably dealt with it, they're so cumbersome and burdensome to the point that they were literally mandating what kind of lotion the inmate could have and needed to have. That at some point our county sheriffs just said, we're done, we're out, we're not going to play this game anymore. And so I think we now see a level of collaboration, which I think is healthy. On the marijuana issue, we obviously don't enforce federal law, from that standpoint, but we do have a system of state laws in Utah that deal with the medicinal marijuana. We don't have rec use, but we do have medicinal marijuana in our state. And most of my involvement, frankly, on that issue, most of our issues tend to be dealing with the Department of Agriculture, who is tasked with facilitating and implementing the regulatory structure for the growing of the marijuana and then the utilization and then the permitting for someone to get a medical card. It's intensely complex. And so there's a lot of back and forth that we need to work through. We function effectively as legal counsel for the state as they administer those laws. And so those are two separate issues, but
I'll just add one more category, and this is what I would call kind of quality of life crimes that often aren't being enforced, especially at the local level. We've seen a lot of course, attention into what President Trump is doing with the National Guard in various cities. And so when I got into the office and I was asking about just ordinary low-level quality of life crimes in Anchorage, Alaska, but for Anchorage, I think the state would actually rank pretty high in terms of, being low on crime. But because of Anchorage and our crime in downtown Anchorage, Alaska is one of the worst in terms of violent crime. Connor, you know. And so what I'm doing on that front is why aren't we enforcing those laws? And there's a lot of Alphonse Gastons, you first or after you, it's not my responsibility. Everyone, at the state level, our prosecutors and the state troopers, they have jurisdiction everywhere, but it's a ginormous state. It's 2.5 times the size of Texas. And so we all have limited resources. And so what we're going to be doing is putting together a task force and using kind of an all of government approach. And one of the sort of soft skills that you have as an AG is the ability to convene. So I can bring in the federal alphabet soup and the U.S. attorney. I can bring in the mayor and the chief of police, and I can bring in the state troopers and figure out how do we work together. I'll take the arrows in terms of going after these crimes, but we got to do something, and I think we will.
Well, I was just going to share an experience on the marijuana issue, and those laws were being enforced in Virginia. And as Attorney General, I also saw how many thousands of Virginians were being criminalized for possession of small amounts of marijuana. Most often they were young people, most often they were people of color, and it just seemed terribly unjust. And so I used sort of that power of convening to announce that we should change this, and worked with the legislature to repeal the criminal aspects to begin to move toward legal regulated adult use. And I think our criminal justice system is better for it.
Well, coming as I do from the People's Republic of New York, I find it really refreshing to hear people talk about actually enforcing laws and issues relating to non-enforcement of laws. Our state, as you know, is headed by an attorney general who ran on a platform of getting our current president. That was it. That was her platform. And she devoted all her energy to it. And so hearing the rather broader focus of state AGs elsewhere is a real treat for me. So I want to express my appreciation to you for that. I think that we ought to leave time for questions. We do have a dinner tonight, so if there are any, I'd like to have people step forward to the microphone if you would. And let's, if anybody asks a question, let it end with a question mark rather than an exclamation point. If you would identify yourself and then tell us where you're from and ask your question.
Hello. Yeah. The U.S. Supreme Court has essentially closed the door on implied private rights of action, except in certain circumstances. But state implied private rights of action, I believe, are alive and well. And I'm asking you questions. Some of this is because some states have declared portions of their constitution as self-executing, and this allows the state to do things that the federal government can't. And as Justice Roberts said,
I think you need to hold the microphone closer.
Good. And as Justice Roberts said, there are three, well, he didn't say two, he didn't say three, but there are three states, there are three sovereigns, federal, the Indian, and state. And have any of these state sovereigns increased their private rights of action in response to the fact that the federal government is no longer in the business of implying private rights of action? Maybe Alaska is the frontier state. I don't know if you've done that or not. Can
we ask the group here to address yourselves to the question of implied rights of action under state law?
I'm too new to know whether this is a problem in Alaska. I will tell you, or I will say that one of the trends that I'm going to be focused on as AG is this trend over the last 20, 30 years of hiring plaintiffs' lawyers to basically bring these sort of lawsuits to shake down companies or to pursue ideological kind of means. We want to make sure that we're threading the needle and making sure that we're bringing the right cases against the really bad actors and focusing on wrongful conduct, because we do have a whole lot of authority as a state to bring these suits. But in terms of implied rights of action that a private plaintiff can bring, I'd have to defer to my colleagues. Mm-hmm.
Well, can I add, we have seen an uptick in PRAs in Utah, which is interesting because traditionally, at least conservatives tend to not like them. I've always viewed PRAs as a how do I put it diplomatically, a transfer of wealth from the private sector to the plaintiff's bar, to put it bluntly. I mean, that's how I've always viewed it. And yet, coming from a state where we have a supermajority of Republican legislators, they, in the last, 5, 6, 7 years, have had this penchant for creating private rights of action on issues involving harms with social media, for instance. And then what they'll do is they'll also give enforcement action to the Attorney General's office as well. So I've seen an uptick in that, which is kind of an interesting development considering that conservatives generally have run the other direction from PRAs in the past. But I think we're seeing a trend of more and more of those.
Well, every state is going to have a different story, but in Iowa, our Constitution is not viewed as self-executing, so that isn't an aspect that we deal with. But we did have our state courts starting to develop a line of cases that would have allowed implied private rights of action. But then at the end of the story, those cases were overturned. So Iowa hasn't been dealing with that.
Next.
Generals, thank you very much. Coach Winehouse, formerly with the Financial Fraud and Special Prosecutions Unit of the California Department of Justice, currently Executive Director of the Cryptocurrency Anti-Fraud Education Association. And I want to ask a question based on what General Byrd talked about, where Iowa is prosecuting cryptocurrency ATM companies who've traditionally attempted to serve the unbanked and underbanked because they are, I think she said, facilitating people being conned out of money by con artists, but not the con artists themselves. So the two-part question, do the attorney generals typically target large legitimate businesses when law enforcement can't stop, for example, in this case, the con artists? And second of all, when you have two protected classes, say the people who are being defrauded by con artists and the underbanked, is there a risk of overzealous prosecution that may end up harming one of the protected classes like the underbanked that these companies are serving?
Yeah, well, thank you for your question. I appreciate it. One of the reasons that we have launched a consumer protection lawsuit against the crypto ATM companies is because as I worked all around Iowa with my relationship with law enforcement, I was hearing from them that this was the latest way that con artists were scamming people out of their money, and people were putting large amounts of cash into these crypto ATMs. It was going into an offshore crypto wallet. So we started to investigate and look into it. When we got to the amount of $20 million that had been taken from Iowans, that was when things started to get very, very serious. And please know, I am someone who believes in freedom for cryptocurrency, that it needs to be something that is allowed to flourish, but a crypto ATM is very different from that. It literally operates as a getaway car for an innocent person's money. When they are conned, they put the money into that machine. The crypto ATM companies help to facilitate that. And one of the most troubling aspects and the reason that we filed that lawsuit was because for many machines, we found that over 90% of the transactions were con or fraud related. And so that was a big red flag for us. We certainly want people to have the freedom to be able to purchase cryptocurrency. I believe in people should be able to have self-custody of their own cryptocurrency if they choose to do that. Those are all very different principles. This is a straightforward consumer protection case. The con artists used to do gift cards, they used to do mailing cash, and they still do, but we found that the crypto ATMs were the ways that many innocent people were losing incredible amounts of money.
And I might add that the elderly, I'm assuming, General Byrd, you probably saw that more often, the elderly are the ones who, and in fact, I know someone personally who had like their life savings and they were on the way to, to rectify, what they thought was a scam, and they were going to put it all in this crypto ATM machine, only to call their lawyer, and the lawyer went, "Whoa, what are you doing?" And this was not someone who was clueless. This was a very smart business person, but someone who's in their 80s. And so we're seeing a lot more of this, and we're seeing a lot of states. Some states are just outlawing these crypto ATM machines altogether. I mean, I know Utah's looking at putting some protections around them, but there's a whole new frontier when it comes to crypto, what we're doing. We just brought charges against the first person that I'm aware of in Utah who used crypto to purchase child sex abuse material. And we were able to connect the dots in the crypto arena to facilitate bringing those charges. So there's a lot of different ramifications to this, but obviously you don't want to over-prosecute and stifle technologies. And so it's a balancing.
I'll just add to this to reiterate, because I do think it's important, as with respect to emerging tech, we want to foster innovation. Alaska is really trying to become like the greenfield last frontier with respect to crypto and blockchain, AI, emerging tech and whatnot. But if you're going to do that, you're going to make sure that you go after the bad actors. And what Brenna did, I think, is commendable. There's a great op-ed, I think it came out in the last week by Katie Biber, talking about this is actually pro-crypto, because if you want to avoid heavy regulation, if you want to avoid regulation by enforcement or regulation by litigation, you have to go after the bad actors.
Yeah. Some of you may have heard about former Attorney General Eric Holder's recent call to expand the size of the Supreme Court. Obviously, your mission as Attorneys General is to fight back, at least one of them, against federal overreach, which requires an independent court. And my question is, what is your assessment of the current threat to an independent court if Democrats should win a majority? And do you have a view of the proposed Keep 9 amendment, which is now pending in Congress, backed by 100 members in the House and 20 in the Senate? I think it's the most widely supported specific Supreme Court reform now pending in Congress, which would prevent court packing.
Anyone want to start? I'm fine with the current 9. I mean, and it's one of those things where you can only do it once. And, is there a need? I guess that's what I would look at. Is there a need? I mean, there have been, ironically, calls in my home state for increasing the size of the Supreme Court, but I think that's a function of workload and the ability to get things done. I don't know that that's quite the same at the Supreme Court level.
Why don't we take the next question?
Yeah. Hi, everyone. My name is Charlie Schumer. I'm a 1L at Stanford Law School. My question, I wanted to ask about kind of balancing the job of Attorney General with the political realities of it. Some of my classmates have said that maybe they'd rather work for like the SG because it's just so much less political. Of course, like you need to run, most of you need to run for election and you're in the public eye. Do you think that aids or does it maybe hinder your actual role of being Attorney General? How do you sort of manage that?
Well, I think we should always be accountable to the people that we serve. And you look at elected prosecutors. Electing a prosecutor is a very important check and a balance on authority. And so I think it's great that we're elected. Of course, it is different. There is additional work that we have to do. But it's really important with the types of responsibilities that we have, that we are responsible and responsive, keeping every area of our state safe, understanding the latest problems. For all the headaches that sometimes come with running for office, it's also very good that we have that direct accountability to the people. The other thing that's great about being elected that's a little bit different from doing some of the pure legal work in our office, we also get to talk about the issues of the day and just think about how awesome it is to talk about our constitutional principles in a way that are relatable to all the issues that we have before us. And people, when you go out to speak to folks, whether it's farmers or a Rotary group, there are lots of great questions and thought. And that's one of the things that does my heart good living in this country, realizing just how engaged our voters are and how much they also pay attention to the Constitution. Because it starts out, we the people, right? The Constitution is we the people. And if the people don't appreciate the Constitution and fully understand that, it won't be what it could be. It'll just be some words on paper. So that's a great part of the job of being elected, but it's not easy.
Given the time and the fact that we've got a dinner tonight, I think we've got time for one more question.
Thank you.
I understand that the Attorney Generals regularly bring civil litigation against the federal government. And I understand for the current administration, it may not be appropriate or right, but are you prepared to bring criminal enforcement against federal officials if they act unconstitutionally and harm the rights of civilians within your states?
Yeah. Yeah, and I'm not either. That's not. No, I think we've got a lot of things going on.
I don't think it's happening. Okay, I thank the panel very much for that, and it's been a privilege and a pleasure to preside over this. I should ask everyone whether we can please give our panelists a round of applause, which I think they well deserve.